Perhaps the broadest of Congress's enumerated powers is the power to regulate interstate commerce. As there is no federal police power, you'll find that most legislation is actually enacted via the Interstate Commerce Clause. The Interstate Commerce Clause gives Congress the authority to regulate in three general areas. First, Congress has the authority to regulate the channels of interstate commerce. Examples of this might be waterways or interstate highways, or railways or even airways. If we were to use the stream of commerce metaphor, you would think of the channels of interstate commerce as the stream bed through which the stream of commerce flows. Second, Congress has the authority to regulate the instrumentalities of interstate commerce. Examples of this might be trucks or their drivers, or the cargo that they're transporting between states. If we were to continue the use of the metaphor, the instrumentalities of interstate commerce might be the water flowing through the stream bed. Third, Congress has the authority to regulate those actors or activities that have a substantial relationship to or a substantial impact on interstate commerce. When trying to assess whether an actor or an activity has a substantial effect on interstate commerce, courts will generally aggregate or consider the cumulative effect of individual actors or individual activities. In fact, Congress's authority over the regulation of interstate commerce is so broad that it may permissibly try to pursue non-economic purposes by use of its Commerce Clause authority. For example, the Civil Rights Act of 1964 outlawed certain forms of discrimination in employment and public accommodations. Even though Congress had an ulterior non-economic motive, because the statute satisfied the general requirements of the Commerce Clause, it was upheld. However, Congress's authority to regulate interstate commerce is not unlimited. The 10th Amendment specifically prevents Congress from regulating the states directly. Congress may regulate states via generally applicable laws that apply to similarly situated state and non-state actors. But Congress may not commandeer the legislative process of the states, for example, by forcing them to adopt a particular regulatory regime, nor may Congress compel the state executive branch to enforce a federal program. You should note that the commandeering doctrine does not apply to state courts. Congress can force state courts to hear federal causes of action. You may remember these general ideas from the Supreme Court's decision in New York versus United States and in Prince versus United States.